What legal protections exist for unsecured debt? Have you ever wondered what happens to unsecured debt when someone files for bankruptcy? It's a common concern, and understanding the legal protections available can really help. Unsecured debt includes things like credit card balances, medical bills, and personal loans. These debts are not tied to any specific asset, which means they can be tricky to manage. When a person files for bankruptcy, particularly under Chapter 7 or Chapter 13, they may receive a discharge. This discharge releases them from personal liability for most unsecured debts. Once granted, creditors cannot take further collection actions against the debtor for those debts. In Chapter 7 bankruptcy, this discharge often happens quickly after any non-exempt assets are liquidated. In Chapter 13, the debtor proposes a repayment plan over 3 to 5 years, and any remaining qualifying unsecured debt may be discharged at the end of that plan. Another important aspect is the proof of claim requirement for unsecured creditors. In bankruptcy cases, these creditors must file a proof of claim with the bankruptcy court. This document formally notifies the court and the debtor about the creditor's claim. If they fail to file this claim on time, they might lose the right to collect the debt through the bankruptcy process. This step ensures that unsecured creditors have a chance to assert their rights. Unsecured debts usually have lower priority compared to secured debts in bankruptcy. Secured creditors have claims backed by collateral, giving them superior rights to recover losses. Unsecured creditors may receive partial payments or, in some cases, no payment at all, depending on the debtor's available assets. However, bankruptcy law provides a structured way to handle these debts fairly, preventing aggressive collection actions during the process. Once a bankruptcy case is filed, an automatic stay goes into effect. This stay legally prohibits creditors, including unsecured creditors, from continuing collection efforts. This means no lawsuits, no wage garnishments, and no phone calls demanding payment. This protection gives debtors relief from harassment and allows the bankruptcy court to manage the orderly resolution of debts. In Chapter 13 bankruptcy, debtors propose a repayment plan lasting 3 to 5 years to pay back some or all of their unsecured debts. The amount paid depends on the debtor's income, expenses, and total unsecured debt. Creditors receive payments through this plan, and any remaining unsecured debt may be discharged after successful completion. This process allows for manageable repayment while providing a structured mechanism for creditors. Legal protections for unsecured debt in bankruptcy include the possibility of discharge from personal liability, protection from collection actions through the automatic stay, and the requirement for creditors to file claims. These protections help balance the interests of debtors seeking relief and creditors seeking repayment. Understanding these protections can provide clarity and peace of mind for anyone facing financial challenges.